Here we go. Good morning, everyone. Half a day, and welcome again. This is day 3 for the Guam Coalition's No More webinar, and we're talking about identifying and responding to stalking. We've got special treats for you today. We've got our key partners who'll be presenting, and we'll be focusing, yes, primarily on prosecuting and on investigating stalking cases. So besides Jennifer Landhaus, the director for SPARC, we're going to see Mark Kurkowski, who is actually retired law enforcement officer with the St. Louis Metropolitan Police Department. So we're excited that he's bringing to us his 24 years of experience and training in investigating incidents of intimate partner violence, stalking, and sexual assault. I just needed to remind myself that we have our ASL interpreter, as well as our captionist trying to keep up with me. So I will slow down a tad bit. Good morning again, everyone. And as you are tuning in, we're just going to go over and briefly introduce our key speakers today. As I was talking about our friend with the St. Louis Metropolitan Police Department, retired from there, Mark Kurkowski, who'll be leading this morning's session with Jennifer. And after the two, they'll be handing it off to Jane Anderson, who brings her expertise in prosecuting domestic violence, stalking, sexual violence, and human trafficking as her role to her role as attorney advisor with Equitas. Prior to Equitas, she served as a prosecutor in Miami, where she tried many of the state's first human trafficking cases. So we've got we've got certainly folks with extensive experience in many areas, not just in stalking, but we're focusing on stalking today. So we just wanted to give it a moment, and we will officially start at the top of the hour so you can all join us. And do test your fingers in the chats, and certainly start chatting so our partners here will know where you're coming in from. And yes, we had Jennifer the past 2 days, but we've got Mark and Jane who will be getting to know more about you as well. And oh, here we go again. Thanks, Sarita. Well, you know, this is 2 days in a row that you were the first one to log in. And thanks to everyone. Sarita's from Sanctuary. We've got folks from Guam Community College joining us. And I'm going through the list and I see folks even from Palau. Thanks to Hilda, our partner with Palau Community College, who's joining us, as well as her colleagues from the Ministry of Health. So thank you, folks, for joining us again. I see familiar names. I see names of those of you who have been with us since day one, which is great to know because for those of you who are seeking CEUs, yes, you have to join us from starting from day one in order to be able to obtain those. So we'll get started in a quick moment now, as I'm pretty sure the bells in the cathedral across the street will soon be letting us know that we are at the top of the hour. So as I've noted, just wanted to start out, of course, with saying thank you to our funders, because without their support, we wouldn't have been able to provide this webinar to you. So that's namely the Office on Violence Against Women, as well as out of DHHS, the Family Violence and Prevention Services Act, and locally through our Governor's Community Outreach Federal Programs Office, we are utilizing our STOP funds from the Department of Justice Office on Violence Against Women to be able to provide this webinar to you. So yes, we are certainly focusing on law enforcement and prosecution today. But as advocates, this is certainly a good time and opportunity for you to also know and understand how you can better support victims and survivors of stalking so that we can certainly bring offender accountability to the picture. So for webinar materials, just a reminder, if you haven't already, visit guamcoalition.org. there is a login at the top of the corner. It's a blue button. So when you click on that, the username is not your email address. It is the word stalking. The password to use is capital S, capital A, capital R 2021. It is case sensitive, so that's where you will find it. I know the past few days we've been getting emails saying, oh gosh, where's your handouts? Well, we finally posted up the latest updated version, and it is one huge document. Go ahead and download that. But if I may ask you not to print it, it's over 200 pages. So what we will be doing is dividing it up into the slides for each day. So that'll be an easy reference for you. And it will also be easier perhaps for you to download and print as you wish. So again, that's on our website, www.guamcoalition.org. The other things too, as I briefly mentioned earlier, if you are interested in obtaining continuing education units or CEUs, we are appreciative of the University of Guam for allowing us to be able to offer one CEU for the 10 contact hours that we have for this seminar, for this webinar. Of course, that is at your cost, but you will need also to contact them directly. On our website, we also have the forms that you will need to complete in order to email to pip@triton.uog.edu. Your input is valuable and important to us. So please complete the evaluation. The link to the evaluation is also embedded on our website. And that is the link. So please, after each day, you will get a reminder, of course, and that's from Zoom saying, Cynthia's reminding you to please do your evaluation. So appreciate your doing that as well. So just a heads up, tomorrow's day 4, and this is what we have in store for you. And we'll see more of Jennifer also speaking, focusing on risk assessment and safety. So just wanted to remind you that if you have any issues or have any problems accessing the information or want us to repeat anything, or you thought you heard something on this webinar, email us, info@guamcoalition.org. But if you're having trouble accessing the site, or your link is not working, or you can't find today's link, because today, every day is a new Zoom link, please call the office 671-479-2277. And one of our team members here at the coalition will be happy to assist. So you'll be able to get on. Because yes, go ahead and email me, but while I'm doing the webinar, I may not get to your email immediately. So best to call us in that case. So we want to thank you again. And I see that many of you have noted or introduced yourselves on the chat. So just a word of note, our presenters actually prefer you to comment in the chat. So you have the power in your hands. So if you want just the panelists to know, so note that when you make your comment. But if it is something that you wish to share with all, you're able to do that. So you will have to do and hit panelists and all attendees in order to broadcast your message to everyone. So then again, I think I've shared enough. Just wanted to remind you, please, we've got our social media sites. We Facebook, we tweet, we Instagram, we blog, we do many of these things. Gosh, some of these things I don't do other than Facebook. So I know if you want more information, we'll try to keep up with the times as well and have that available. Again, www.guamcoalition.org, where we have most of our information as well as our calendar of events and any updates to our activities with the coalition. Also wanted to take this moment to tell you that you can also go and check out our online community directory. www.pacificregionresources.org. For some reason, though, if you're trying to reach the Dedido Mayor's office and you're searching online, you will get our phone number, but we will continue to assist you and give you that number as well. So just wanted to thank you for joining us this morning. And I will go on ahead and pass it over to our partners. Then, did I miss anything?
I don't think so. Thank you so much, Cynthia. And just a huge shout out to Cynthia and the staff at the Guam Coalition. They have done an amazing job putting 4 days of training together. They make it very easy for those of us as presenters to just show up and talk. So a huge shout out to all of you and to your funders, and a big thank you for that. So I'm sure all of you are very excited to not have to listen to me for a full 2.5 hours on day 3. So I would love to have my co-presenters take a brief opportunity to introduce themselves. I'm going to start with Jane Anderson, who is our prosecutor. So you're going to hear from her at the end of our time today. But Jane's going to tell you a little bit about herself, and then she'll turn it over to Mark to be able to introduce himself.
Hafa day, everyone. I was lucky enough to visit Guam in person for an elder abuse training about 2 years ago. So I'm jealous I'm not there live to talk to you all, but excited that you are spending this amount of really specific and intentional time to talk about stalking. As a prosecutor, I spent the first part of my career only handling misdemeanor domestic violence cases. And I saw firsthand how challenging it was to investigate and prosecute stalking. And we sort of made it more difficult on ourselves because I think we didn't quite understand all of the dynamics, and we weren't using all of the tools in our tool belt. So I'm hoping that I can share with you some of those lessons learned and strategies that can help prosecutors be more successful in these cases. So I'll talk to you guys in the sort of second half of today's training.
Thanks so much, Jane. Mark, do you want to introduce yourself to the crowd?
Sure. My name is Mark Kurkowski. I'm a retired law enforcement officer from St. Louis, Missouri. I retired in my 27th year, and during that time, I was assigned to our domestic abuse response team. And within our DART unit, I was assigned to 2 additional grants during about a 24-year period.
Thanks, Mark. So for those of you that aren't familiar with DART, that's the Domestic Abuse Response Team. So Mark, just for the rest of today, just a reminder to spell out any acronyms you use, because we do have ASL interpreters and closed captions on the webinar as well. So any questions from the last 2 days of training? Anything that has risen up for you, or anything that you would like to pose as a question, or something that you want to make sure that either Mark or Jane address during our time today? So this is your chance to be like, I really hope Jane talks about, or I really hope Mark talks about, and go ahead and put that in the chat so that we make sure we spend some time talking about that today. I've had the privilege of being with all of you for, this is now day 3. And so I've gotten to learn about the amazing work that you are all doing, both in Guam as well as in other parts of the country. But this is Jane and Mark's first time joining us. So it's been my experience for the past couple of days that most of you are representing victim service professions or college campuses. If we have anybody on that is a law enforcement officer or a prosecutor, and you feel comfortable letting us know in the chat, would you just let us know that, just so that we have that heads up? If you're worried that we're going to pick on you, use the question and answer box to tell us that you're a law enforcement officer or a prosecutor, because you can be anonymous there. Oh, yay. Okay, John, you're a prosecutor. And John, you've been here the whole time. So my bad that I didn't realize that we had a prosecutor on, because I think I remember answering a question or 2 from you the past couple of days. Or I could be making that up because it is day 3 and it's all starting to run together. Anybody else that wants to volunteer information? Or last chance to ask them. Oh, I see some in the Q&A. Okay, so somebody, I'm looking at just, somebody's responding. It looks like there might be another person who's on that responded in a Q&A, and just a couple of folks saying that they have several individuals logged on to one computer in their particular office. So it'd be nice to have in-person contact with other people. I think I speak on behalf of Jane and Mark when I say that I really miss in-person contact with people. So I'm glad that you're all able to do that. So I'm going to go ahead and bring up our PowerPoint for today if nobody has additional questions, but again, feel free to pose them in the chat. So what we're going to spend some time talking about today, just to give you kind of the layout, is Mark and I are going to take the first part of this particular session where we're really talking about the investigation piece of things. And then, because I am not a prosecutor, nor do I, no offense, Jane, ever want to be a prosecutor, I am going to turn it over to Jane to fly solo for the second part. But I'm certainly here and listening, and will chime in if need be. So I feel like Jane, you know, having a child that wants to be a prosecutor and is maybe headed to law school, then at least, you know, I sort of acknowledge. All right. So let's talk a little bit about what we're looking for when we're investigating these particular cases. And just a shout out again to Spark's funder. Certainly the Guam Coalition has its own funders, and we've made sure that we express our appreciation and thanks to them. Spark is funded by the Office on Violence Against Women to do training and technical assistance specific to the issue of stalking. So Mark and I have actually known each other for, it feels like forever, Mark. It's probably 10 plus years that we have been teaching together on the issue of stalking. Both started as consultants for a different national program that taught on stalking, and then have continued that work with the creation of Spark. And so Mark was still in law enforcement when he started teaching with us, just recently retired, but has a wealth of experience working not only on domestic violence issues, but on stalking specific issues, which is kind of rare to find around the country when you're finding law enforcement that is focused on specific stalking issues. So just again, a reminder about Spark's website. The prosecution guide to stalking is on this website. We're currently developing additional resources for law enforcement, so keep your eye out for those as those come across the website. And then you'll find out that those are coming if you follow us on social media or if you sign up for our newsletter. So just a reminder that those things exist. And then a reminder today that we're going to be really delving into more the criminal side of things and the criminal definition, but that we're still really basing our understanding and our talking about stalking on our behavioral definition that we've covered, and then really looking at what course of conduct is and how it's directed at victims and the additional people outside of victims and beside victims that are affected by this issue. And then focusing on the what's it like to feel fear and who's a reasonable person. And I know Jane's going to get into that more when she talks about the prosecution piece of things, but just again, a reminder that this is the behavioral definition, but we certainly are going to focus in on more of the criminal components when we look at these particular issues. So the thing that we want to start off with is the acknowledgement, and probably not surprising to many of you, that about only anywhere from 5 to 16% of stalking cases are actually charged as stalking, even when police have all the information that they need to charge. So why do you think that is? And again, I'll encourage you all to use the chat system to interact with all of us. But why do we think we aren't necessarily charging these particular crimes, even if we have the information? Or if you are somebody who's been assisting victims, what have been the reasons that you have heard given to victims from law enforcement or from prosecutors about why these didn't move forward? Tony's saying it could be hard to prove intent. Okay, we're going to talk about that. Why else do you think we might not charge these particular crimes? Tony's absolutely right. Why else, or what else have you heard from victims? Because the victim is inconsistent. Yep, absolutely. What else? Okay, because victims don't want to prosecute. And we'll talk about whose decision it is to prosecute or not as we move on through our day today. What else? Oh, somebody was listening. They said, I mentioned the other day that we didn't ask about stalking. Yay, somebody was listening. Okay, Theo gets the gold prize of the day. Yeah, sometimes it's because those stalking crimes are occurring and we're not asking the right questions, right? Or we're not identifying them within the context of domestic violence or sexual assault. Someone also mentioned plea deals, right? So we might have started with a stalking charge and then it was pled down for whatever reason. And I know that Jane does an excellent job of explaining what the burden is that a prosecutor has to try to overcome and what some of the strategies are when we choose to charge something else other than stalking, right? John also mentioned that we don't have the technology to collect information, okay, from the phones. So one of the things, Jane, that we talked about yesterday when we were talking about technology and gathering that technology as evidence in some of these cases is that Guam is a little bit unique and much like some of my law enforcement agencies in Idaho, and a little bit different from those of you big kids like you and Mark who run in the big cities and have access to some of that more adept technology. So I can give as an example, I did 2 webinars this week. One was for folks in New York City, and one this morning was to a very small agency here in Idaho. And they would resonate with what you said, John, that something like Cellbrite or other technology doesn't even exist for the folks in Idaho. Whereas the New York folks were telling me that they could bring a car in and scan for GPS devices and other things on the car. And I was like, oh, wow, that would be so nice, right? John's also mentioning that with limited resources, you have a tendency to focus more on cases in which an injury's happened. So the actual physical injury might weigh in more so in the decision to charge than the emotional impact or than other things that might be more difficult to prove. Anything else that anybody would want to add? Mark, stuff you would want to add from your experience? Why is it, Mark, that your people don't actually make decisions to arrest for stalking? Why do you think law enforcement doesn't do that? Anything you would want to add?
And I think technology can definitely play a role in that. Sometimes victims might think that they're not going to be able to move forward because we don't know who's behind that technology. And yes, Jennifer, that is true. We do have Cellbrite and all of those nice things with our department, and some departments might not have access to that, but it doesn't mean that we still want to document. I think documentation is one of the biggest things we want to focus on when we're trying to build a stalking case, which we'll talk about in a little bit.
Yeah, and so we've talked a little bit about what that documentation looks like, but I think it's always really nice to hear from Jane and Mark some of the things that they're specifically looking for as they're looking at arrest and prosecution decisions. So I think that's absolutely accurate. So Mark, I'll let you take over for this next particular slide as we pose some of these questions and look at some of the reasons why victims aren't reporting.
Right. So one of the biggest things we see is minimizations. Victims will minimize the situation they're in. I've had actual cases where one of my victims was shot, and it wasn't the first time. And when we look at that type of behavior in that incident, we want to see what else is occurring in that situation. A lot of times, so the minimization we see as a huge issue, and a lot of times it could be a private or personal matter, or reported to another official. And a good example of that reporting to another official could be a college campus. I think we have some campus individuals on as a participant. So it's really important to focus. Just because the police department is involved, it doesn't mean that other resources cannot be involved. And sometimes there's a confusion with that when victims are trying to report that, especially when you have jurisdictional boundaries, which could play a huge role in that as well.
Yeah.
Some people and victims think that it's not clear if a crime actually occurred, because when we look at that stalking behavior, and Jennifer has already talked about all the behaviors and the diff patterns in that situation, but again, victims might not think it's important enough either. So that's what we want to look at. And if that technology is playing a role in that situation, we want to make sure that we can try to prove who is behind that technology. And did you do the tech part already, Jennifer?
Yep, we did tech yesterday.
Okay, that's what I thought. So hopefully after seeing that, it is, I don't want to say it's easy, but there are ways to find out who is behind that technology. So hopefully we can see that. But there is cases in stalking that there might be a lack of evidence. Or if we don't have the course of conduct, because that's what we have to have. We have to have 2 or more acts over a period of time to develop that course of conduct to prove that stalking incident. And then also victims will say there's fear of reprisal. And of course, anytime victims reach out to law enforcement, that puts that victim at a higher risk of being harmed or killed. And you'll learn about that tomorrow when you discuss the threat assessment.
I appreciate you mentioning that, Mark. I think that's one of the things that we have to keep in mind, that fear of reprisal is very, even though it ranked low in that particular list, it's something that we hear from a lot of victims that, I don't want to get the offender in trouble. So I know that we have several participants from the military justice system on with us and have been with us for the last couple of days. And so some of them were reporting that, sometimes it's easier to go through the military system because there's been some swift and, pretty intense consequences for the offenders. Other times there's that confusion of, do I access justice through the military system? Do I report it outside the system? This is a closed system a lot of times where lots of people know things. And so I think keeping in mind that, victims have lots of reasons why they're not reporting things. But as we've mentioned and talked about the last couple of days, not only fearing reprisal or simply just understanding what constitutes stalking, right? And so one of the things that I would encourage all of us to consider is when we have victims that are coming forward to report, either to someone who's in law enforcement or even to those of us that are victim advocates or working in a victim-based system, we have to keep in mind that by the time they're reporting to us, they have already tried things to make the stalking stop. And so one of the best tips that I can give to you as far as building rapport with your victim is to ask victims, what have you already tried? As one of the very first questions that you ask when you're working with a victim. Because my experience has been that it creates an instant rapport because number one, you're acknowledging that the victim has already tried some things and it hasn't worked, and that's why they're there. And because then we don't immediately jump into, so for instance, if that person is like, I already went and tried for a civil protection order and it was denied, and they come and sit across from Mark and at an interview table and Mark says, well, you should get a civil order protection, then the victim might immediately think that Mark doesn't know anything because the first thing he said is go get a civil protection order and I already tried and I didn't get one. So it's worthless for me even to be sitting here talking to Mark. So establishing rapport with victims, asking, what have you already tried, as well as things like, what are you not willing to do? Some victims will say, I don't want to tell them to stop because I don't want to have any contact with them. Some victims will say, I'm not willing to go see a counselor, or I'm not willing to talk to somebody at my job because I'm embarrassed and I don't want everybody all up in my business, okay? And then I also like to ask victims, what would you like to do and you need my help with, okay? Some of those individuals want help reporting to law enforcement. They might say, I really want to report to the police, but the last time I tried to, it didn't go very well. So I would really like you to go with me and make a report. And Mark's not just saying this because he's on with a bunch of victim advocates, but he's a huge proponent of victim advocacy. And so I'm sure he'll talk about that in our time together today. But considering the fact that victims, by the time they reach all of us, have already tried things, a lot of times they are changing their activities. They may have already tried to block the call or try to identify caller ID. And we talked about all the problems with that yesterday, right? They may have stayed with friends. They may have missed work. They may have put locks on their doors, etc. So that acknowledgement that they've probably already tried things by the time they're working with us is really important. It's also really important when we say, what have you already tried? Because sometimes victims have made a report to law enforcement And they come and they're sitting across the table from Mark, and Mark says, well, I don't have any reports on file. And then the victim will turn to me and be like, what do you mean they don't have? See, I told you they don't know what they're doing. They don't have any reports on file. Well, Mark can pull up reports from the city of St. Louis because that's who he works for. But pulling up the county or the next city or whatever might be a lot more difficult. And so one of the things that we have to keep in mind is that oftentimes victims may have made a report that didn't get written down by or logged by law enforcement, or it may have, and this particular jurisdiction doesn't know about it because it happened in another jurisdiction. Okay, so keep in mind that when we talk about that documentation log that I showed you all earlier, and we logged where things happen, and we're going to talk again tomorrow about those safety measures, documenting where things happen so that we can establish jurisdiction is really important. Okay, go ahead, Mark.
You know, go back to that screen there, Jennifer, and you make a really good point. When we look at all of those countermeasures that victim has incorporated, and you're right, sometimes when it comes to us, the incidents are already there, but are they documented? Let's take, for example, a simple destruction of property case where he came over, smashed out a window of the car, but nobody actually saw him do it. Is that actually going to get documented in a police report? Did she call 911? Those are the things that we have to ask first and foremost, just in case that she did call 911 and a report was not made for whatever reason. That's another reason why it again is so important for documentation, just in case that she tried to report it, but for whatever reason, the officer didn't take the actual police report because we can't prove who it was. And I've heard that before, and it just makes me go crazy because we know every single thing that she's trying to report is a separate act of that course of conduct that we're trying to prove in that stalking case. So when I see all of these things on the screen there as victim countermeasures she's trying to do to protect herself, that perks my ear up as law enforcement. And hopefully it does for other law enforcement, but for victim advocates, that's a way for you to chime in and look at, there's no way, or you can start seeing that those countermeasures are ways to, I start identifying that behavior in that stalking case.
Yeah, excellent point, Mark. Thank you.
And so I think another really important aspect of it is that why is it important to charge any applicable charge? And that's really important because we know that stalking behavior is going to include different acts or different events. And if it is a violation of a law, if you have the destruction of property, if you have the violation of the order of protection, if you have an arson, we want to also include those specific charges because number one, it gives a prosecutor at that time to look at individual acts that have occurred from day one until whatever's occurring at that time. So that's really important to know that that's how we build that stalking case now and for the future. And it's also important to know that stalking charge can either result in one, stopping the stalking, or being able to build that better case if that stalking behavior continues. And I think that's another really important thing to think about because when we look at stalking cases, we know, especially with orders of protection, my experiences in handling order protection violations, when law enforcement goes out and serves that order of protection, before the end of your shift, you get a call from that victim saying he violated the order of protection because he called her. He's yelling and screaming at her, why did you get the order of protection, calling her names? That is a clear violation of that order of protection. And we want to make sure that we document that because that could be one separate act of the course of conduct over the period of time. And it's really important to see, and just in the chat, if we could ask, has anybody had stalking cases where the offender was actually charged and the stalking stopped? Has anybody had that experience? Jennifer, help me out just to make sure I'm not missing anything. I don't see anything. So there's no, so okay,
Yeah.
At least you're responding. So, you know, everybody's saying no so far because a lot of times we do see that stalking behavior is going to continue. So it's really important to charge whatever crime is occurring at that time. And again, it can help you down the road, or down the road when another officer gets the call, because it could be in another jurisdiction as well. And I know you're going to hear me time and time again talk about documentation, but especially if you, for example, live in the city and then you go out to the county and work in the county, or you have parents that live in another jurisdiction, that's what's really important. So we want to look and see where those crimes are occurring, and making sure that that victim is documenting everything in that situation. But you can see also that increases plea bargaining options, sentencing options, and enhanced penalties in some situations and jurisdictions, just like in Guam. So when we see that opportunity to enhance that penalty, that's what we want to try to prove to our prosecutor. And Jane's going to talk about that in a little bit. But it's another way, number one, we can hold our offenders accountable for their actions, and number two, making sure we keep our victims safe.
Mark, someone's asking in a question and answer, if you can talk a bit about the importance, or maybe lack of importance, depending on what your answer is, about making a timely report. What are some of the benefits of somebody coming in and reporting to you right away that a stalking crime happened? And if somebody, waits 2 weeks, what difference does that make in your case?
And that's a really good question, because I've had cases where the crime occurs, they call right away, and it is beneficial in some instances, especially if technology is involved. Because if the offender went out and created for example, a fake Facebook profile, and then all of a sudden he took it down because it didn't get reported yet. Well, are we able to backtrack that information? Or if that profile is still available, that's what we want to know about, because we caught it in time before that offender took that profile down. So that's, I think, a really good example of technology. When technology plays a role in that type of situation, we want to get that information as soon as possible, because the more it sits there, the more opportunity that evidence is going to disappear. And you can kind of use an example for even text messages, very common in stalking cases. And again, it's that evidence that we have at hand. We want to make sure that we can obtain it right away. And then I've had cases, for example, that the victim didn't report it until 2.5, 3 years down the road. And a case that comes to mind is literally, she was not only sexually assaulted, but strangled to the point of unconsciousness. She had pictures she took during that, but she did not want to report it at that time. She waited all of that time, and then more stalking behavior occurred during that time, including text messages, postings on Facebook, and things like that. But we were able to go based on what evidence she still had, and that was witnesses that witnessed part of that physical assault and pictures that she had at that time. So we were able to go back 2 years prior to that, and it doesn't happen often, but it does depend on what evidence you have to see if you can proceed with those criminal charges. So to answer that question again is more, it depends on the circumstances, but I always like to see it being reported right away, especially if technology is involved. I don't know if that answered the question, but.
I think it did, Mark. I think the things to think about are, it doesn't necessarily impede Mark's ability to investigate the case. It might impede charges, depending if we have statute of limitations. But I know that Jane is going to talk about building that course of conduct and going back to the very first incident that happened. But I think it also then can be a little problematic from the defense side of things, who will say, well, if the victim was really so scared, why did it take them 2 years to make a report to Detective Kurkowski? So it's not something that we can't overcome. If it's been a little while since the incident happened, it just sometimes makes it a little bit harder. So one of the things that I always have the conversation with victims about is to say, it's helpful if we make a report right now. If you're concerned about that, can we keep documentation? Can we keep pictures like that victim had or something similar? Sometimes they're scared to report right now because they don't want to talk to police by themselves. But sometimes they're like, I can't emotionally do it right now. And that's okay. It doesn't mean that we still can't try to build those cases. They just might be a little bit harder. And I appreciate that John mentioned, even sometimes when we do build those cases and we do make an arrest, the stalking behavior continues from jail. So Mark and Jane, I think, will both talk about how we see offenders oftentimes violating civil protection orders, continuing to make threats to witnesses via phone calls from jail. Okay, it's a pretty common tactic. And I saw another question pop up in the question and answer. Okay, perfect. They said we did answer those questions. So, all right, go ahead, Mark.
So I think another really important thing for law enforcement as we look at this is that first response. So anytime a victim reports any type of harassing behavior, look at it as a possible stalking case. And we see harassment as a separate charge. And it's something that kind of gets confused when you look at stalking charges. So the easiest way I always like to look at harassment versus stalking is, do you have a course of conduct? If you do, then you have that element of the crime to charge stalking. If you have that one separate act, then you can charge the harassment. But you have to consider charging that harassment charge could prove to be a good thing because you are actually charging a crime and you're documenting it. And you're not documenting it not just through the victim, but through law enforcement and the prosecutor's office. Because when you do that, you can definitely see that full course of conduct as you go along. So that first contact's critical. You may determine how the victim continues to work with law enforcement. And I think that's really important. That initial contact is so important because that is what the victim is going to decide if she's going to contact law enforcement in the future. And that's really important. And we see that's really important. The other thing is to have resources on hand. And again, make sure that if it's a handout or a card or something, make sure that we give that to our victim on every single case, because it's important to reach out to that victim advocate, to do a threat assessment, to do a safety plan, to make sure that victim stays safe in that situation. And again, and I know I sound like a broken record, but preserve that evidence right away. Take pictures of text messages, get screenshots of anything that's online, whether it be Facebook accounts or if he created a fake profile. And then be prepared for the long haul. And again, some of these cases do take a long time, and doing that good job now at that hand can help others down the road. So it's really important.
I agree with what you said, Mark. I know you and I have had lots of discussions that your supervisors absolutely loved how much time you spent on stalking cases, right? They were thrilled that you would spend, 6 months trying to build a stalking case, right? They loved that.
Yeah, don't go there, because that wasn't always the case, obviously.
Yeah, we know that these cases take a while to build, right? And I think what Mark said that could easily be missed is maybe that first report that the victim makes to law enforcement isn't something that we have probable cause to be able to make an arrest or even prosecute. But it doesn't mean that we still don't take the information, that we still don't write the report, because it is about helping that next person down the line, not only the victim, but your fellow officer, fellow investigator, et cetera. Because if you put something in place now, perhaps it is that property destruction or something else. When the next person gets the call, or when the victim reports the next thing that happens, then we have two incidents. And it's easier for Jane to prove a case in court if she has multiple incidents. And it's easier for Mark to make an arrest if he has multiple incidents. So one of the things I say to law enforcement all the time when we do training is, it's not just about making your job easier, it's about making your colleagues' job easier when they get the call in 2 weeks. Because they will, okay? Go ahead, Mark.
So there might be times where we don't have enough to charge stalking, and it's unfortunate when that happens, but those cases do happen where we just don't have that course of conduct. But it's that time we want to think about what other incidents are occurring at that time. And I'm going to mention orders of protection because Jennifer and I have had this discussion time and time again. I'm a big fan of orders of protection because it gives law enforcement the right to charge and arrest that offender at that specific time, whatever is occurring as a violation of that order of protection. But we know filing for that order of protection, being served and going to the police again, all is part of that risk that that victim is taking just by taking those steps. So it's really important, again, to reach out to that victim advocate to make sure a safety plan is enacted if that victim goes and files for the order of protection. It's really important. The other thing I wanted to mention and make sure is if we do see multiple violations of the order of protection, we can charge both violating the order of protection and stalking. There's a case, the State versus Cortez Hardin. It's a US Supreme Court decision that specifically was ruled that you can charge both violation of the order of protection and stalking. It was an actual case of mine, and the Supreme Court ruled that, I believe it was in 2015. So I'm really a fan of that order of protection because we were able to prove and show all those violations of the order of protection. And in that case, there were also domestic assaults that occurred, as well as a rape and kidnapping incident. So again, showing that other charges, it's really important. And that offender was sentenced to 87 years in prison. So again, we don't usually see that high sentence, but because of everything that was occurring in that case, we were able to get a good conviction on that. Again, it just depends on what is occurring in that situation, but we want to file those other charges. We want to make sure that we have a warning call if it's a call out to the offender. If we don't have proof or that course of conduct, we can call out to that offender, stop calling the victim. If you don't, you're going to be arrested for stalking or harassment or whatever the case might be. So it does require monitoring the case. And again, as a victim advocate, you can help that victim go along that procedure by showing that documentation and helping that victim log what is occurring in that situation. And again, use resources, whether it be police or whatnot. The resources are a huge thing when we look at stalking cases.
And I want to respond. I know earlier in the chat when we were talking about victims and what can impede investigations and prosecutions, someone mentioned that inconsistent response from victims. I don't know if anybody has ever worked with a victim where the victim was able to sit down and start 10 years ago and chronologically walk through everything that's been happening in those last 10 years in a nice, neat, linear order. Trauma does not work that way. People won't recount events that way. And especially when you're dealing with stalking cases, that victim might sit down across from Mark and say, so let me tell you, he has been leaving all these messages on my website, and blah, blah. And Mark's like, oh, it's not a crime, lady. Like, what do you want me to do? And then she's like, and then he did this, and then he did this. And she's jumped out from like 14 different incidents. And I can see the response in Mark and other investigators' faces where they're like, I have no idea what you're talking about, because they've jumped back and forth. And so using a documentation log might be beneficial, not only in logging evidence, but in helping victims be able to tell a more linear story. But I think the other thing we need to remember is when we have these interactions with victims, realizing that they might overfocus on one particular issue. They might say things like, well, I just want you to know, I don't want the offender to be arrested. Which then I've seen officers, not Mark, but others who are like, then why did you come report to me if you don't want them arrested, right? And victims have also many times tried to take measures into their own hands. They've tried to do things to make the stalking stop, right? So keeping in mind that as we talk about these investigation questions that Mark's going to talk about in just a second, we have to be prepared for some of these common responses from victims, right? I think
I
when we
think
talk, oh, go ahead.
Go ahead.
See, Mark and I are not presenters who are like, you take slide 5, I'll take slide 6, because we talk together and present all the time. So if we stumble over each other, that's why, because we feel like this should be more of a discussion and supernatural instead of like, you take one slide, I'll take the next. So I'll shut up, Mark, and you go.
Oh, no, you're good. So again, when we're looking at investigations, we need those context questions because that's really important to focus on. When we look at context in stalking cases, especially when we're looking at fear, that's what we want to know. And again, it depends on the situation, but context is crucial when we're working with these types of cases. And again, it's that repeated unwanted contact questions as well. And we're going to go over some of these. And again, the really thing that we're trying to prove, because when we look at this stalking case to present with or to the prosecutor, we're going to have to try to prove to that prosecutor and ultimately a judge and possibly a jury why that victim is in fear and show that course of conduct over a period of time. So it's really, really important to look at those.
Mark, there's a question in the chat from somebody who wants to know for places that don't have victim assistance programs in their police department, okay? They don't have anybody working in the prosecutor's office that's victim witness or victim assistance. Do you connect them with nonprofit organizations like their local domestic violence and sexual assault program? Have you done that in the past to help victims?
Yes, I have. There's something called Victim Connect. And I think, Jennifer, there was a slide, and I don't know if it's after this presentation or one of them, because me and you present all the time, so I'm not sure where it comes into. But Victim Connect is a really good way. If you don't have a resource for advocacy, you can contact that number, and they're really good in trying to find an advocacy program in that area. It might not be 5 miles from where you're at, but it hopefully, and again, it depends on if it's a more rural area, there might not be anything available up to an hour away. But Victim Connect is definitely one way to do that. And I think another way is to start looking at other resources that are out there, even if you're law enforcement or if you're working as a victim advocate. And I think there's another good way, and Jennifer will talk about it tomorrow again. Look at SHARP, because SHARP, it's a threat assessment tool that will actually give you a safety plan. And I think that's really important to know that after assessing the risk that victim's in, there's a way to actually let that assessment tool develop a safety plan for you. So I think that's another way you can benefit from that.
And I think both Mark and I would definitely be huge proponents of and understand that some police departments and prosecutors' offices don't have dedicated victim service professionals because they don't have the funding, right? But that's where it's so important to have built rapport and relationships with the people in your community. Many of you know one another, you work with one another on a frequent basis. And so really being familiar with what people can do, we understand that there's a level of confidentiality with nonprofit community-based advocacy. That does not mean that they can't work together with police, okay? So as long as we're honoring that confidentiality, that we're understanding what one another's roles are. Mark and I have disagreements about stalking cases all the time because I have an advocacy background and he has a law enforcement background. It doesn't mean we wouldn't still continue to work together for the betterment of those cases. So keeping in mind that absolutely we would recommend that law enforcement be working with the NGOs in their area as well, okay? Somebody was also asking, Mark, like if you have, say for instance, your ex's younger siblings that are bothering you on Facebook, seeing who you talk to, et cetera, start harassing your friends, and somebody's tried to report to police, but they said because that individual was a minor, that the minor needed to be in the accompaniment of a parent to make a report. So I think the short takeaway from that is, what happens when you have a minor in these particular situations? What kind of reporting can you take?
Yeah, I guess it would really depend on policies Number one, you have to go by whatever policy is set up. And if it does require that juvenile to be with a parent, then so be it. And that might happen. I'm not sure if that's a requirement in your area or not, but you would have to look at the policy. I know there's some issues right now, whether what is a juvenile, age 17, age 16, or age 18. So that becomes kind of a role that you have to look at in each individual situation, and go from there. So I guess the best way to answer that would be, what is the policy based on that department and that agency?
Yeah, because we've really seen it vary across the US and the territories about what's permitted and what's not permitted. The other answer I would give you to for law enforcement who might wonder about that is the old check in with your prosecutor to make sure that you're doing things correctly and what they want to see. So let's talk a little bit about offender history. And remember, when we've been talking a little bit about offenders, and what we're going to spend some time about talking about tomorrow is that it's not going to be uncommon to be working with offenders in these cases who have no criminal justice history. They are really adept at talking their way out of things. And so Mark's going to go over some of the history questions that you might want to ask in these particular situations to give us a good understanding of what that relationship's been like.
So I think the first thing you want to do is look at the prior relationship history. What is the relationship?
There you go. You lean closer to your mic because you're I think it's just the bandwidth is cutting out a little bit.
Oh, okay. So it is, what is that specific relationship between the victim and that offender? Is it a dating relationship? Is it a former girlfriend, boyfriend, spouse, former spouse? Those are the things we want, because again, that can be a determining factor in that enhancement when it comes time to charge that individual. So that's why it's really important to know that offender relationship and what type of contact was made during that situation and how frequent was it. And Jennifer talked about those DIF patterns, and that's a duration, intensity, and frequency. Those
I haven't talked about those yet, Mark. That's
you
coming
haven't talked
tomorrow.
Okay, sorry about that. So when we look,
a preview of tomorrow,
yeah,
they're not going to show up tomorrow now.
So that is something that we want to look at to see that frequency again in that contact. Again, that could be part of that course of conduct that we're looking for to prove that stalking case, though. And is that suspect aware of their actions are being unwanted? So again, it's something that offender is going to come into play and say, well, no, this is why I did this. And we'll talk about that in a minute. But remember, any contact by the victim could increase their risk. That's another safety point when we're working with stalking victims.
So remember how we spent some time the last couple of days talking about disengagement and how, we want victims to not have any contact with the offender, but that's not always the reality. So keeping in mind that sometimes victims having contact with the offender might increase the situation, right? We've spent a lot of time talking about, there's a lot of, well, maybe, and ifs, we can't entirely predict what might happen in these cases, but we will spend some time talking tomorrow about the duration of these cases and how intense they are and how frequent the stalking tactics are, because that plays into safety concerns. So that's what Mark's referring to when he talks about the DIF patterns. And I put that in the chat for you if we talked about that too quickly. The other thing that I think we need to be thinking about when we're talking about working on these particular cases is, again, going back to our first day together and establishing the context. So really trying to get an idea from both parties what the relationship has been like, what's normal, what's not normal, what's changed, what's not changed. I think the most telling interview I ever sat in was the detective in that case was asking the victim, how do you two know each other? And the victim's like, we went on a couple of dates. I wouldn't even say we're dating. And then the detective is interviewing the offender, and the offender says, well, I was going to ask her to marry me. And I was like, whoa, huge difference in responses, right? So understanding that context, right? Someone's asking Mark, how often does stalking occur where there is no previous relationship? And have you investigated those they don't know each other type cases?
Oh, and that's a good question. And obviously we focused on those intimate partner cases, but there are cases that others might be stalked. For example, whether it be an actor, an actress. I've had cases of politicians being stalked by individuals. So yes, it does occur. The domestic relationship is something I focused on as part of my investigation, but there were times that others were part of that stalking as well, and we see that. So, it's for an issue of prosecution. It can enhance that penalty based on what is occurring in that situation. But again, it doesn't matter. We just want to make sure, again, it's a matter of documenting the behavior, seeing the course of conduct, and proving all of that to give to the prosecutor and move on with a successful investigation and prosecution.
So to your question, I'm missing who asked it, but certainly like some of these slides might not apply if it's not an intimate partner relationship, right? But some of them will, like these ones, like had to ask the victim to describe the contact. They might not have had a relationship with that person, but they can still describe the contact that's happened, right? And what we also haven't talked about is also understanding that in some cases, you might have a victim coming in to report something and they don't know who's stalking them. Okay. It certainly makes it easier if we know who the offender is, but it's not unusual for us to have cases where the victim's like, I'm having all this happen to me and I don't know who's behind it. Okay, so still questions about this, the contact here can be applied to intimate partner or non-intimate partner. And these emotional distress questions about how the contact made you feel, why it scared you, explaining it in your own words, at what point. Was it every contact? I think one of the things that sometimes gets misconstrued in stalking cases is that fear can be retroactive. So what I mean by that is someone may meet someone else, and I'm referring to that interview I just talked about where the offender said we were going to get married and the victim's like, no. In that particular case, the victim on like the second time that they went out with that person, the offender showed up with like flowers and was like really over the top. And the victim said in the interview, you know, when that happened, part of me was a little taken aback, but now looking back on it, like that should have been a warning sign to me that this person was way more into me than I was into them, and that they were really strong in their feelings. And so the victim didn't feel fear when they got flowers and that over the top reaction at that point in time. But now looking back at that particular incident, now they're like, whoa, this was like the first kind of red flag I should have had in this particular situation. So keep in mind that a lot of times when we're looking at these particular cases, the contact might be different and the questions might be different. And to your question, Raul, is there something like a protocol on the appropriate handling of these offenses? Many times that will be department specific. So when Mark was saying check the policy, he was referring to a department specific policy on stalking. Departments should have a policy on stalking. Many of them, Mark's shaking his head because we encounter this all the time, many of them don't. And so one of the things that we always recommend when we're training law enforcement specifically is to say, you need to get a policy in place, okay? So that whoever handles this case, it's handled in the same way. So we would certainly have ideas and some like generic policies and procedures that we would recommend, Raul, but we would then say we can give those to local law enforcement, and then we would recommend like one-on-one working with them about building their agency policy. So part of the technical assistance that Spark provides is working with an agency one-on-one to develop their policy. And we have lots of model policies that we can pull from that people can use. They do not have to start at square one, and we would encourage them not to. So the overall answer isn't like, you can't Google like law enforcement policy on stalking and get one policy that every agency goes by. even if you have a policy in your agency, you're going to have an officer like Mark who follows it and wrote it, and another officer who's like, oh, I don't want to deal with that. Okay, so it's going to really depend. I wish
And I
there
think,
was a model. Go ahead, Mark.
and I think another thing to go from there is on the Spark website, there's a checklist. That's another thing that you can focus on. And it kind of gives you an idea of how to handle or what to do in that stalking situation. Jennifer, I hope I'm right on that. I hope I'm not imagining that, but I want to say I saw it on the website recently.
It's because you've seen the document, it's not on the website yet. So stay tuned, everyone.
Okay.
It's being looked at and revised at this particular moment in time. So what we do when we develop stuff is we bring the brains like Mark and other people together, and then we also send it around the country to get other people's opinion on it and come up with a final product that has to be approved by our funder. So it's a long and tedious process that I won't bore you all with, but stay tuned. So if you want the in process hasn't been formally approved, send me an email and I'm happy to send it to you. Okay, but it's coming out soon. All right. So again, we're not going to go through all these questions directly as far as like, you know, what do you ask in fear and emotional distress? The one that I would point out on the screen, and then I'll give Mark a chance to weigh in, and I know that Jane really likes this question too, is to ask victims what they have done differently as a result of the stalking. So remember on day 1 and 2 where we talked about how victims don't oftentimes articulate fear, but their behaviors might show us that they're fearful. Asking them what's changed in their life can make a big impact and can help us prove some of these things if we're trying to prove emotional distress or other things. Mark, any other particular questions on this slide that you would point out?
I think when we're looking at fear and emotional distress, a really good question is kind of along the lines of a trauma-informed question, which would be, tell me more about how that made you feel afraid. And that's where you can get a lot of information out as well to prove that's the situation at hand, and that's why the victim is afraid of that individual. So I think it's another really important question to ask.
Yeah. And as far as the respondent goes, or the defendant, or whatever you want to call the offender in this particular case, getting a timeline of events from them, but focusing in on things like, you know, you texted the victim 37 times and you didn't receive an answer. Tell me about that. And so you can try to prove that the offender should have known that the contact was unwanted, right? Or, you know, the victim told you to leave them alone and you continue to contact them. Like, what was your goal in that contact? So to that end, then, how would we try to prove in these cases that the suspect should have known that the contact was unwanted? Because every offender in stalking is going to say, well, I didn't know that the victim wasn't in love with me, or I didn't know that they didn't want to have contact with me. How do you try to prove that they should have known that? Think about some of the things that we've talked about so far in the first couple of days. Anything coming to mind? They were told it, yeah, right? So remember the text message that we looked at where the victim said, you're scaring me, leave me alone. And some people are like, I don't know if she should have done that. We had that discussion about, is it going to escalate things? Is it not going to escalate things? But one of the things that I said is, well, sometimes prosecutors and law enforcement want to see that clear, I told them to stop thing, right? So from Mark's point of view, that might be helpful. And from Jane's point of view, because they told them to stop, right? Somebody said when the victim said that they felt uncomfortable, etc. Anything else? You know, when I call Mark 37 times and he doesn't answer, because he does that to me, is that probably a hint that Mark doesn't want to talk to me? Because usually when I call somebody 37 times, they might answer, right? Okay, so thinking about that as and asking questions about, you know, how has that happened? How many times have you called that individual? Somebody was saying, you know, a victim doesn't answer the call. What if a victim's in shock or scared and doesn't protest? Then what? Mark, have you ever had to work beyond a victim didn't say anything, but the offender should have known?
Oh yeah, there's no questions. And even working with our advocate, I had a luxury, I guess you could say. I was able to bring all my cases to a victim advocate that worked directly with our unit. So that was advantageous because we can do a safety plan right away, but that's not always available, obviously. But in some of those cases, she didn't want to come forward. And I'll always remember this when I was sitting in my office and the advocate's obviously in a different office, but I saw a victim that I worked with previously walk by my door, walked into the advocate's door, and I was thinking, oh, I'm going to have to arrest this guy again. He must have did something else. Well, the victim walked past me and that was it. And because of confidentiality, I still to date don't know what occurred, but I do believe that there was an assault, but she didn't want to report it. So we do see that. And there's all kinds of reasons why victims don't want to come forward at that time. So it is something that we look at. Yeah.
So somebody's also saying, taking note of when calls come in where there are 37 back-to-back calls within an hour, 37. Yep, we've talked it. Yay, you guys are applying all the wonderful stuff that we've talked about the last couple of days. Somebody also asked on the fear and emotional stress, how about if the stalker was an intimate partner, but a strange partner of the victim who knew a lot of private information? How do you go about it? This becomes a very dangerous case, right? When they're a current or former intimate partner. And before Mark gets the chance to answer, Raul, I would say, yes, when we do threat assessment tomorrow, we're going to talk about the fact that intimate partners pose a much higher level of danger in these particular cases. But when they, and we are getting ready to go on break in just a second, so we're just going to wrap up this particular section. But just real quickly, when you have those intimate partner situations and they do know a lot of information, or they can guess passwords and stuff like we've talked about lately, trying to draw that line in the sand where we try to say, okay, the victim has communicated to the offender that the relationship is over. That's where things like, you know, is there a civil protection order in place? Have they filed for divorce? Has the victim communicated to the offender? And where that comes in place also is when we as responding law enforcement might be able to make a warning to the offender to say, look, you're not wanted here. The victim has told you that you need to stop and you need to stop having contact. Law enforcement can do that. Some people do it by letter, some people do it by phone contact, keeping in mind you know, what the policy is in that jurisdiction, but sometimes that can be incredibly useful in those cases. And the thing that we would oftentimes hear, and I've heard Mark say this so many times in presenting together, that offenders will oftentimes, as their first thing that they say to Mark is, this is just a big misunderstanding. And Mark, what do you say back to him?
And just tell me how you're misunderstood. And sometimes that'll do wonders, sometimes it doesn't. But that is a way to get your offender to talk sometimes, because they always think that they are right in their behavior. So it's really important to know.
And what I would say to that is, for those of you that are doing victim advocacy services, it's really important to be able to have conversations with victims about the interview techniques that a law enforcement officer might use. I have seen Mark do interviews where I wanted to throw up afterwards because he is the offender's best buddy. Like, I'm 900% sure that he's going to lead that interview and they're going to go get wings together and watch a football game. And I'm like, this is disgusting, because he has built rapport with the offender as an interview tactic to get information. Okay. If victims don't understand that, what the offender says to Mark, or what the offender says to the victim is, I had that officer eating out of my hand. He loved me. He knows how wrong you are. So as victim advocates in these particular situations, or as law enforcement or prosecutors dealing with these cases, it can be important that you help victims understand some of those techniques and why law enforcement or others might ask those questions, because one of the techniques that they may use is to build rapport with the offender. And oftentimes things like, oh, tell me how you're misunderstood, or yeah, I've been in a terrible marriage before, I know how hard that could be, can get offenders to confess to things, okay? So as we head off to break, just remembering some of the strategies that we're going to use in these particular cases as law enforcement. And certainly this is, you know, an hour and 10 minutes of content versus we could do a full 40 hours of an investigation. But understanding that we're going to build on a lot of things that we talked about as far as identifying stalking within the context of domestic violence, the specialized training, the using the risk assessments, which we're going to talk about tomorrow, and really becoming familiar with your support networks. So, Mark,
No, if I
any
could just
last-
add one more thing to add to that slide, and it's crucial. I'm not just saying this because you're the coalition, but I firmly believe in a community coordinated response. And that is crucial when we look at these types of cases. So that's the ability to work with not only law enforcement, but prosecutors, judges, probation and parole, family services. Everybody in your community can come together and look at that situation to see what we can do to make sure, again, keep that victim safe, number one, and number two, hold that offender accountable for their actions.
So we're going to go on break now. When we come back from break, Jane's going to be our lead presenter. Mark and I will still be here in the background. But pose any questions that you have. Otherwise, come back at 20 after. Thanks, everyone.
Happy day, everyone. Welcome back. We'll be starting momentarily with Jane Anderson for the next half of our webinar series for you. So thank you for joining us. Don't forget, if you have any questions, feel free to post them in the chat. We also have the Q&A if you wish to remain anonymous as well. So please log in, and we see that many of you continue to be with us. So thank you. And in a moment, you'll see Jane. Thank you.
Okay, can everyone see my screen and video? Yes. Great. So I want to transition to sort of talking about that prosecution piece that we've been teasing a little bit. But I want to start with looking at the legal definition of stalking, because I think up to now we've been talking about a behavioral definition. And there can be some little nuances that are important to know about when it comes to what can we actually charge. So I've pulled the Guam statute. I'm sure some of you are working with different statutes that I wasn't able to find on my Westlaw, but I'm happy, and Equitas is happy to do a statutory analysis for you if this is something you'd be interested in. So this should all look very familiar to you. A person is guilty of simple stalking if she or he willfully, maliciously, and repeatedly follows or harasses another person, or who makes a credible threat with intent to place that person or a member of his or her immediate family in fear of death or bodily injury. So we're going to break this down a little bit, but I wanted to also mention, as Mark did, that there are often enhancements to stalking. And in your case, there's an advanced stalking subsection that talks about how the stalking can be charged as a higher crime when it's done and there is already a restraining order in place, an injunction in place, or a prior conviction that has occurred in the last 7 years. Those things sort of bump it up. So not only can those restraining orders and injunctions help to protect the victim, they can also provide us with stronger charges to move forward with. So the statute goes on to sort of define some of the terms that are in that definition. So harasses, of course, is one of those terms. And I'm not going to read you this entire definition, but again, it goes back to this knowing and willful course of conduct. And it can be physical, it can be verbal, it can be written, it can be digital, it can be in person. They really lay out all the different ways that it can happen, but it has to be directed at a specific person, and it must alarm, annoy, or distress that person. And it has to cause a reasonable person to suffer substantial emotional distress, and it has to actually cause the victim in the case substantial emotional distress. So I have looked at a lot of stalking statutes across the United States and the territories, and there's always a few things that come out to myself, right? And so that is, what is the harm that the statute talks about? Like, what has to happen to the victim? And in this case, it's kind of nice because it's language they use such as alarm, annoy, or distress, right? It doesn't talk about fear, which a lot of the statutes have to talk about fear. But it does also say it has to suffer substantial emotional distress. So it can be annoying, but it also has to cause substantial emotional distress. So those would be things as a lawyer I would be interested in trying to figure out how I'm going to show that a behavior annoyed my victim to the point that there was substantial emotional distress. Okay, so you guys have talked a lot about course of conduct. In your specific statute, it doesn't say 2 times, 3 times. It just says a pattern of conduct of a series of acts over a period of time, however short, evidencing a continuity of purpose. So I would say at the least 2, 3, as a prosecutor, you know, someone comes in with a case with 2 text messages over a week. Does it technically fit that? Maybe, but probably not something that we would be charging at that time unless they were sufficiently threatening or something else was going on, to be honest. Credible threat, that's another way you can prove stalking. That one is a little bit more self-explanatory, right? This is somebody that is threatening you or your family and has the apparent ability to carry that out. So I put together a little chart based on your statute, and I thought it might be helpful. So all of the defendant's behavior has to be willful and malicious, right? That's the top piece. So that means we have to prove that it wasn't an accident. That's usually not a high hurdle. But we also have to prove that it was done with malice, which means that a defendant could legitimately come in and say, hey, none of this was done with malice. All of this was done because of love. And so, you know, that's something that as a prosecutor, I would have to make sure that I had my eye towards that possible defense. We see that in, you know, movies and music, and I'm sure you guys talked about it. Sort of these demystifying of stalking as romantic, right? So that's something I'd have to address as a prosecutor. If the stalking included things like, you know, sending someone flowers and sending somebody cute memes, those types of things. Okay, so then you can do stalking in 3 different ways after that. One is repeatedly follow. That one doesn't have any more instructions under your law, and it probably would be sort of more of our old-fashioned, what you might see somebody walking down the street, showing up everywhere. That all you have to prove is the repeated following. The other second way that you can prove stalking, which is usually the one that most of our stalking kind of falls under, is under this harassment. And we looked at that definition. And so to prove harassment, again, we need a knowing and willful pattern of conduct. It needs to be directed at a specific person, needs to alarm, annoy, or distress that person, and cause that emotional distress. Those are individual elements to the crime. You need to prove all of those things. And the third way that you can prove stalking is by making a credible threat. And that has to be death or bodily injury. They have to have the intent and apparent ability to carry out that threat. And it has to cause the victim to reasonably fear for their safety or the safety of their family members. So hopefully that kind of gets that all of that dense language a little simplified for you. And that's what we're going to work on. So of those elements, what do you think some of those challenges are going to be? And we talked about that, right? Intent. And I'm going to get to reasonable person in a second. What are the challenges? So I already sort of pointed out that it might be a challenge to establish maliciousness or malice. It might be difficult to establish that severe emotional distress. Your law doesn't go on to further explain what that is. There's a Supreme Court case that's talking about another statute that has very similar language. It's actually the federal statute. And it says these terms have, they're regularly known and they don't need any more definition. So not incredibly helpful. The apparent ability, right? So if somebody says, I'm going to kill your children, and they're maybe not living on Guam, that might be a hard thing to prove. But if that person has access to the children and shared child custody agreement, that would be something easier to prove. So that could be an issue for sure. So the reasonable person standard is a little bit interesting because reasonable person standard is what the law uses to talk about sort of neutral person. This is a normal person that, and it's the opposite is called a eggshell person. Eggshell person is very easily damaged and is very, very fragile. Reasonable person is sort of this neutral person that the law just, it's a term of art for legal purposes. But it could be interesting because with stalking, we know how important context is, right? So I'm sure you saw the video of the spider that scared somebody. It's scaring me as somebody that's not particularly afraid of spiders and doesn't have an allergy versus someone who's bitten before and had to spend 3 weeks in the hospital after that spider bite. Those are going to be two very different responses. So the law does allow, and sometimes this is written in the law itself, sometimes it's case law, sometimes it's just the argument that the prosecutor needs to make, which is that that reasonable person is a reasonable person in the same circumstances and in the same context as a victim in our case. So you sometimes do have to make those arguments, but I'm glad that you pointed it out because that's definitely something that could come up as a defense in this case, which is this victim overreacted. A normal person would not have reacted this way. So we're going to go through some case examples. So our first example is Alan and Betty, their ex-boyfriend, girlfriend. During the course of their relationship, Betty sent Alan naked photos of herself. After they broke up, Alan sent an email to Betty's sister and mother attaching some of the photos. Alan also sent an email to Betty threatening to send the photos to Betty's boss and coworkers if she called the police. Okay, so for purposes of this, let's get our chat fingers ready. Do you think Alan's email to Betty's mother and sister were directed at a specific person? Yes, yes. Yes. Yes, I love that you're all saying yes. So there are arguments out there that are being made that that email wasn't directed to Betty. That email was directed to Betty's sister and Betty's mom. And so a prosecutor can sometimes get derailed by that and needs to remember that what is the purpose and intent of the offender. And that behavior was in fact directed at Betty, despite the fact that the email was directed at her sister and mother. So there's a little legal nuance there. So that's the argument, of course, that you would make. Now, what if the court did say, you know what, that email was directed to the sister and the mom. I don't think it was directed to Betty herself. Then you're in a spot with, can you establish a course of conduct? And so that course of conduct can get really complicated when we're talking about tech-related abuse, because it's a course of conduct, right? Well, what if I sent one email, but I sent it to 500 people? Is that only one act, or is that 500 acts? So the law has not made these decisions yet, but I always like to point out what we identify as emerging issues. And if you couldn't say this failed, your arguments failed, and the judge said, no, this was not directed at Betty. The second email was directed at Betty, but not the first one. What do we do then? Because I think we all agree that this behavior of Alan's should be criminalized and he should be accountable for that. So I wanted to point out, a couple more laws in your toolbox. And so Guam passed a couple of years ago a statute prohibiting the unlawful distribution of images. This is often referred to as revenge porn. Well, we don't like that term, but it kind of it got a hold of the public imagination. And obviously that's how it's often written about in newspaper articles and things like that. So that's what this is really about. And it's recognizing that, I think in large part recognizing that the exchange of intimate photographs is sort of part of modern dating, and that those photographs, when exchanged, even if consensually exchanged, they should be held with trust. And so this sort of, there's lots of ways this happens, but sometimes it's exactly how Alan used it against Betty after the breakup. Sometimes the pictures are surreptitiously taken, hidden video cameras and things like that. But oftentimes the most difficult and harmful ones are where it was photographs that were consensually shared and then non-consensually distributed. And so this statute allows for you to prosecute that type of behavior. You do have to prove that there was a reasonable expectation of privacy. And that is normally something that can be talked about as what the course of their relationship, and did they share it with anyone else? It does not need to have like an explicit contract attached to that. When it talks about some further definitions, disclose means to display, to distribute, to publish, and any electronic means can be used here. And the harm can be physical, it can be financial, or it could be severe emotional distress. So that same sort of language that you heard in your stalking statute. So when we have that image-based abuse, this is a great statute that might be easier to prove than a stalking statute. But just like violations of injunction charges can be charged alongside stalking, so could this. You could charge stalking and you could charge this. I wanted to include some resources if you're handling cases like that. Oftentimes victims will say, the only thing I want is I want these pictures taken down. I want this person to destroy those pictures that she may have in their possession. And some of these really great work is being done, especially for the Cyber Civil Rights Initiative. They've stopped Google searches and things like that. So a good resources. Okay, so we have another case example here. Chris and Dan dated a few times, and then Dan stopped texting Chris back. Chris sent Dan 150 texts in the last 30 days. The texts were not threatening and were mostly cute emojis, GIFs, and memes. Chris also sent Dan food delivery to Dan's work 10 times. Dan is reporting this to the police and says, I just want this to stop. My boss is super annoyed and I think I'm going to get fired. Okay. Do you think Chris is stalking Dan? Why or why not? We've got a yes. Somebody was brave enough to answer first. Great. So if people want to maybe put in what they're thinking about, right? So these are all signs and behaviors of stalking. We have the course of conduct. We have that it's unwanted conduct. But do we probably have annoy, right? In our scenario, Dan says to the police, my boss is very annoyed. He doesn't actually say he's annoyed. Potential financial impact if he loses his job. So this is a male victim. And sometimes you can have even more difficulty working these types of cases when the victim is male, because you have this overlay that a man isn't allowed to say he's afraid or that he's emotionally impacted by this behavior. So you may have to really work with Dan to get to a point where you could say there's some substantial emotional distress. And so as a prosecutor, I would probably lose my case if Dan took the stand and just said, well, I wasn't really bothered, but I thought I was going to get fired. That probably doesn't rise to that level. If you could get Dan to open up a little bit more about, like, I never told Chris where I worked and he found out, or I had to have all these private meetings with my boss. My coworkers were like not inviting me out anymore. I was being ostracized. I was afraid I would never work in this industry again. Like those types of things. Or I made this a little vague here. If Chris is a man and this turned into something where it could be potentially outing somebody that wasn't ready to be outed, then we could get even further. So I think I put this in here to demonstrate that even though the behavior is repeated and annoying, you still have to do that extra work to get to emotional distress. However, you do have additional crimes. Like if we never got there with Dan and all he could say was, I'm annoyed, we may not think stalking is appropriate, but we may want to look at harassment. Or if Dan filed a court order or a violation, protective order, then you could go towards that way of violation of that court order if it continued. So a couple of other crimes that I wanted to include, I always think you've got to know the tools in your tool belt. And so when stalking doesn't fit, or when you can charge multiple things to start increasing offender accountability, then you can sort of start building a case where criminal mischief is your property crime, plus your violation of a court order, plus your identity theft because they made a fake Facebook account, and then you're stalking. All of a sudden, we're really looking at being able to hold somebody accountable in an effective way. I have a question here. Are there additional charges if there is a two-party consent to take nude photos and the victim didn't know? What if the victim is considered a minor? Okay. So if you've got an image case, if their victim is a minor, you're going to start looking at child pornography as the crime, not this. And I'm not sure if there's a two-party consent to take nude photos and the victim didn't know. If the photos were surreptitiously taken, so with a hidden camera or in a private area, like somebody in a locker room or something like that, usually there are additional charges for that look like video voyeurism or peeping Tom statutes. I didn't necessarily find that when I was going through your statute, but it's be happy to look into that more for you if that's something that you want to look at. Identity theft is one of those ones that I don't think people think about enough when it comes to stalking behavior or tech facilitated intimate partner violence. Often people have ruined people's credit. They have put new accounts online, a case where they were opening up electric bills in somebody else's name because they had access to a lot of their personal information and were able to do that, or credit cards. So really look at that. If you've got any of those signs, your statute is pretty open. I looked at it and it looked like that was going to cover a lot of that material. You actually also have 2 acts that cover a very broad range of tech-related crimes, the Computer Protection Act and the Computer Spyware Protection Act. So those are other places where you could start looking at additional charges when you've got those tech crimes. And then, of course, your witness tampering, intimidation, and bribery crimes. So oftentimes when I was prosecuting misdemeanor domestic violence, I would also charge stalking, because stalking sort of covered this sort of wide range of activity that was happening in the course of the relationship. Some of it legal, but added to the fear, added to the intent. Some of it illegal. And the other thing we don't necessarily think about all the time is that this, let's say you have a domestic assault or battery, and when you're talking to the victim, you realize, I really have a stalking case that's part of this domestic relationship. You should, and you look backwards, which is great. You should also start looking forward, because we should be very proactive about educating our victims about witness tampering, making sure we're identifying evidence of witness tampering, and that we're charging it. And those types of acts also could be part of a stalking incident, or a stalking course of conduct is a better way. So your criminal intimidation is sort of like an extortion, all those different crimes you really want to be thinking about, because that will maximize your toolbox. So charge stalking when appropriate. Think about charging multiple victims. When you have that third-party victim, let's say those emails sent to Betty's sister and mom, if those continued, Betty's sister and Betty's mom could also be listed victims separately under different stalking charges when appropriate. Look for all those other charges based on the course of conduct. Giving somebody flowers, maybe you can't charge that separately, but maybe it's in a violation of an injunction, and you could. And the property damage and the spyware and all of that. It really paints a picture, because these cases are often minimized. Judges, juries, defense attorneys, they're going to say, the victim could just change Facebook accounts. The victim could just ignore it, right? These are crimes that are often minimized and can be minimized by the victims themselves if we're not providing them with the support to really recognize what's happening. And so if I go into court as a prosecutor and I'm reading my charging document, my indictment or my information, and it says stalking, violation of injunction, violation of injunction, violation of injunction, criminal mischief, impersonation, and all of a sudden there are 20 different crimes, everybody's ears are going to start perking up and recognizing that this isn't just, one thing that the victim was annoyed with, but this was really a serious course of conduct. Use the risk assessments that are particularized to stalking. I know Jennifer gave you those. Those can be used for making bond arguments, making sentencing arguments, formulating a safety plan, but also just personally doing some triage. We all have a ton of cases, and some cases you're like, you know what, this case, I'm going to bring out the big guns. I can't hire an expert in every case. I can't file motion after motion in every case, but this case, I'm going to do it because of the risk assessment that Jennifer will tell you all about tomorrow. Make sure victims have meaningful access to those services. I know that's not that's not my lane, so I'm going to stay out of it a little bit, but you know how important it is. And as a prosecutor, it was important that I knew how important it was as well. So you can do some training of your prosecutors that you work with as well. Files motions to introduce other bad act evidence that demonstrate context, intent, motive. So for the lawyers out there, you guys are familiar with your other bad act evidence. And it allows us to bring in evidence of other acts that the defendant committed that weren't necessarily part of the charged crimes. One of the good things about stalking is that we don't have to file these as often, because stalking serves as this sort of umbrella charge where we can just bring in everything. But sometimes it's good to file this anyway. Does anyone have any ideas? I'm not going to wait too long, but one of the things that it can be helpful with is that the stalking crime, like the charge itself, is not going to have a lot of information in it. It's literally going to sort of just mimic the language of the statute. But when you file a notice of other bad act evidence, you actually have to specify all the other acts, and you have to provide any witnesses or documentation of those other acts. Sometimes this is also required in stalking. They call it like a bill of particulars the defense can ask for. But what it does is it puts them on notice. Like, we're not playing here. We're going to talk about this. We're going to talk about this. We're going to be talking about this. When I charged these, great, Tony, showing that proof of escalation, you might also have other acts that are outside of the window of statute of limitation. The statute of limitation doesn't apply to other bad act evidence. So that might also be a reason why you do it. I found that when I filed a really like detailed motion on this, I would get the defendants asking for a plea offer very quickly, because it shows that we're taking it seriously, that we've done our research, that we've compiled all this documentation, and that we're taking it very seriously ourselves. We can admit expert witness testimony, and that can be very powerful. We talk about it in domestic violence cases, in sexual violence cases. I do it in human trafficking cases, and we should think about doing it in stalking cases as well, because they could talk about, just like Jennifer would be an awesome expert witness. I just have her on the stand and be like, hey, would it be unusual for a victim to minimize stalking behaviors? And then she'd be like, that's not unusual at all. And I'd be like, why? Or what, what's happening there? And she'd be like, well, I don't know this victim. I'm not involved in this case, but I have served hundreds of victims of stalking. And it's very common that they'll end up minimizing things, especially at the beginning or whatever she would say. That way, your judge and your jury are seeing the evidence through the lens of that expertise. And it really can help them, not make incorrect credibility determinations of your victim, because expert could also maybe explain why the victim can't put things in certain orders of chronologically, and a little bit about trauma. So that can be very, very helpful. Again, kind of like when you're ready to bring out the big guns. And a lot of these things are places where you can ask us for more information, because I'm just touching on some of these prosecution strategies. Another one is litigating forfeiture by wrongdoing when victims are unavailable to testify. And I'll give you a little bit more information on that in a sec. Support the victims filing for protection orders. Do they need copies of police reports or photographs or some of the evidence you have? Make sure that they have access to that. Ask for case-specific pretrial release orders. So our orders usually said no contact, and then they would maybe say no third-party contact, but we eventually started making sure that they also had information about using technology to contact. And so if you have a case where all of the contact is through Twitter, ask the court to make that a specific thing in that order. so that the defendant can never go back and say, I didn't know. I wasn't told I couldn't use Twitter. I was told I couldn't text her. So think about anything that might be case specific that you want included in those orders, and then enforce those orders. So I know that Guam has pretrial release orders that are included in all of your intimate partner violence cases, including stalking. And they include firearm prohibitions. And this sort of is the same with your civil protection orders, right? So if they violate that pretrial release order, then you make that argument they shouldn't be released. A motion to revoke or motion to, put new orders on there. However it works with you. With bond reform and COVID-19 things, I know this is a little bit more up in the air right now. But anytime a defendant violates a court order, whether it's a civil order or a criminal order, judges have the inherent ability to hold them in contempt for violating that order. We don't use our contempt powers enough. Those can be very swiftly done, and oftentimes, and there are some jail time is attached. Your other bad act evidence, we can remember it's not only previous bad acts, it can be post bad acts too. So ask to talk about that at your trial. Let's talk about how after he was arrested for this, he continued to contact her and he continued to do this. And then of course, other charges, if that contact includes things like witness intimidation, tampering, or bribery. Here, and I included a lot of this stuff so that you'd have it as a resource. And if you work with prosecutors, feel free to share these slides with them as well, because we really want everyone to be hearing the same information. So this is just the statute that allows for expert testimony. And in particular, I wanted to point out, it doesn't require any certain level of education, PhD. Someone can be qualified as an expert if they have specialized knowledge, skill, experience, training, or education. And the idea is that somebody that knows more than the common person can help a jury or a judge better understand the evidence. And so we're just talking about somebody that's worked with victims. Oftentimes, a direct service provider is an amazing expert witness. Forfeiture by wrongdoing is a legal concept dating back before the United States was a country. But basically it's a concept, right? We all hear about, yeah, I have a right to confront those witnesses against me. That's in our Constitution. Confront those witnesses against me. Well, we all know for years and years and years, offenders have been basically doing everything they can so that the victim doesn't show up in court. And then they say, oops, I guess you have to dismiss the case because I have a right to confront the witnesses against me and the witnesses are not here. And so this has been very effective practice of offenders for decades and decades. And in fact, the first case that we talk about in the United States dates back to the 1890s in Utah. So what this says is that you forfeit your right to confront those witnesses against you if the reason they're not here is because of your wrongdoing. And so basically the witness has to be unavailable. And that can mean a lot of different things. It can mean Mark can't find that witness. It can mean the witness is sitting there in court and just refusing to testify. It could mean the defendant married the victim and is now insisting on spousal privilege. So that's a broad definition. And then the defendant has to do something wrong. It doesn't have to be criminal, and it can actually be pleas, emotional pleas of love and family togetherness. So it doesn't even have to be mean or threatening. It can be loving. And it has to be, you also have to prove that the defendant intended that outcome. That wrongdoing was done, at least in part, to make the victim or witness not show up in court. So we often hear about this on jail phone calls or letters, where we find these emotional pleas not to come to court. And then the next thing, the victim has come and tried to drop the case, right? So we've got to be proactive about it, but it's a really wonderful resource when there's intimidation and tampering going on, because if we prove this, then all of those statements the victim made to the detective, to Mark, to anyone, to family, friends, all of those statements, which otherwise would have been hearsay and not admitted, now all of a sudden they can come into court and you can establish your case even without a victim who is able to testify. We've got lots of resources at Equitas. It's one of our favorite topics. You can find them all on our website, or you can always reach out to us. So those are some prosecution strategies. I know you guys talked about digital evidence and what it looks like and things like that. I want to talk a little bit about how we bring it into the courtroom and how it's so important, because obviously it builds stronger cases. Our juries expect tech evidence at this point, but it also supports our victim by having it so that the entire case doesn't rest on their shoulders, right? It's not a he said, she said, which I hate that phrase, but we all know what I'm talking about. So all of a sudden it's like, no, we have the text messages, we have the screenshots, we believe you, and we are not only investigating this case with all the tools that we have, but we're going to bring it so that you're not the only one that this case is resting upon. So you can get that evidence in all different ways. I mean, this list is growing by the day. I think most of it now is on our cell phones and through apps that are on our cell phones, our social media. But we also are seeing more and more cases that have, fitness trackers or GPS or Wi-Fi enabled appliances. So just trying to keep abreast of all these things. So we talk about cell phones, and what's really interesting is that on our cell phone, we have all these apps, and it is almost a two-part analysis. Can you get into the cell phone? And then can you get into the application? But the cell phone will tell us what apps are on there, so that can be helpful. These are examples of what I'm talking about when I talk about third-party applications. Good old-fashioned phone records. These are still really important for us, even though now there are additional challenges, right? So with the records, we can get account holders, we can get other phone numbers that are associated with the account, and we can get our logs. But we have to remember that a lot of phone calls, to us, they just are phone calls. They're coming in as phone calls. They're actually being sent over Wi-Fi. When they're sent over Wi-Fi, they're not going to show up on your cellular phone records. So this is a place where we need to make sure we're educating ourselves and the judges and jurors, because the defense is surely going to say, you said you received a call, it's not on these phone records. Financial records can also be really important. And I point out these types of records because neither of these record types do you need a search warrant for. You can get these with subpoenas and sometimes with consent, depending on who the account holder is. But financial records can be our bank accounts, our credit cards, our prepaid debit cards. Think about gift cards. Also, if you know somebody's, what's it called? Apple Store account. I'm sure that Jennifer talked about that when she talked about spoofing software. Sometimes the records come back through the financial records and you see a 99-cent download fee or something. So this can be really helpful. Don't overlook that. Don't think we have to be super high tech all the time. Spoofing, I know you guys talked about that, so I'm not going to say much other than there's a stalking case out of Miami where they successfully charged him with identity theft because the defendant was not just putting in random phone numbers to show up when he called. He was actually using known phone numbers of the victim's friends and colleagues, thinking that she's more likely to pick up the call if she recognizes, oh, this is who's calling. And so they charged identity theft for all of those phone calls, and that started adding up to felony charges. If you have like a credit card receipt or something like that, you don't necessarily know who to subpoena because you just have the numbers. You know, if you subpoena, okay, which credit card bought this app, you're just going to get a number, right? Then you need to figure out who owns that credit card. But first you have to figure out what financial institution owns that credit card. So this is a free resource online. There's several of them. I guess they're not 100% free, but you get like 10 free searches a month. And you put in a certain number of the first 6 numbers of your credit card. And then it'll say, oh, this is owned by Bank of America. And then you subpoena those records from Bank of America. So just a little trick there. This is an example of how a case helped me when all I had was that credit card number. I got subpoenaed records from, I think this was American Express. And they said, okay, this was charged at Scooters of South Beach. And then there was a charge at backpage.com. Some of you may have heard of it. It's defunct now, but it used to be the main place where it'd be online prostitution advertisements. And then Scooters of South Beach again, and then Backpage. So obviously it was helpful to see the ads that were placed on Backpage. It was a human trafficking case. What ended up being more important, because I needed to put a person behind that credit card, was the Scooters of South Beach transaction. When I subpoenaed Scooters of South Beach, they gave me the entire rental agreement with name, address, driver's license, where the hotel they were staying. And they also took a picture of my defendant flipping the bird, renting the, sorry, I looked at the ASL translator there. Flipping the bird, I'll just keep saying it. And so I not only had the paperwork, but I had his photograph as well. Rideshare records, again, the stalking case where somebody didn't want to be seen following the victim in their own car that she would identify, but he used an Uber, right? And Uber was able to provide with a subpoena all these multiple midnight trips to the defendant's home. I know we don't have a ton of time, so I'm going to go through. Oh, I think we're over. Are we over? Text
You're
me.
not over, Jane. We have another 20 minutes. You're good.
Oh, okay. IP addresses, also really interesting because we hear about them a lot. You know, oh, that email came from that IP address, but we don't really know what to do with it after that. So IP addresses can be fixed. That means they are assigned to a particular residence or a particular business. But they can also be pooled, which means that they are owned by a cell phone carrier and that they're shared between users. So obviously when the IP address goes to a cell phone, which we know is so much of what is happening, it can be very frustrating because the cell phone company can very rarely tell us what user of the cell phone service had it at that moment in that time. There is a trend because we're running out of IP numbers that we're moving from an IP4 to an IP6 process. So IP4, you see on the slide, it's a couple of numbers with a period, couple numbers. It's a total of 9 to 10 numbers. IP6 is a much more complicated number. Good news is that the IP6 ones, even when they're assigned to a cell phone carrier, can be assigned to an individual user of that cell phone company. So it could help us find that. And again, we have to do a 2-step process to figure out this when all we have is that number. Aaron.net is a free online sort of phone book. So you go on there and you put in the IP address and it'll tell you which internet service provider owns it. So in my world, that might be Comcast or AT&T. And then you do a second subpoena to that ISP and saying, hey, who was that IP address number assigned to on this date and on this time? And then you can hopefully get things back. It's always best when it comes back to a residence. Also can be good if it comes back to a business. It can come back to a cafe. So we've heard of cases where it was always the same time of day and it was always coming from this hot spot at a coffee shop. And they did some surveillance at the coffee shop and there was our defendant at the coffee shop every day on his computer at that place. So things to think about. VPNs, I have not had any luck with that, Leonardo. I can definitely put you in touch with others that may know more than I do about VPNs. So if you want to email me, I know Jennifer put my personal email address in the chat. So one of the things that's important to know is that because of our rights to privacy, a lot of this information we just can't get, right? So we need to either use a subpoena or a court order or a search warrant. And that depends on the type of information we're trying to get and how much right to privacy we have for that information. So content where we're looking for text messages or direct messages, those types of things are found to be, we have a lot of right of privacy to that. So to get to that content information, you're going to have a search warrant. So that's our cell phones, our social media accounts, our computers. And very recently included in that is historical location data, where that's the data that our phone is tracking for us that we don't even recognize that's tracking. And that's because the courts have found that we're not really voluntarily giving that location data to anyone. It's just part and parcel of owning a cell phone, which we all have these days. So it's a very recent case and it's a heightened privacy for that. So now we need a search warrant. Subpoenas is where we can get that subscriber information. That's why we can get banking records and telephone records. There's no content of communication. It's just transactional information. And therefore it's a lower standard. But this is constantly changing, but just good to know for you guys. If you are interested in more of this kind of stuff, there's a really great online guide called search.org. So let's say you have a case that involves plentyoffish.com and you've never heard of that, that website before. You can go onto search.org and it'll give you all the legal information you need to serve that person, to serve that company. There are a couple of listservs and resources for prosecutors and law enforcement. So the digital DA listserv is something that I get all the time. And it's something like you just said, hey, has anyone had any luck with VPNs? Can you help me? And then all these really great people around the country will answer you. And then both New York and King County, Washington, their prosecutors' offices have put up several portals that include go by search warrants and subpoenas. And those are usually limited to law enforcement and prosecutors to gain access to those, but they're really great. Other considerations is something called a preservation letter. So that's basically saying, you send a letter to Facebook saying, hey, don't let anything happen to this account. Don't let the defendant erase anything, delete anything, take anything down. I'll be back to you really quickly with a search warrant. And then you have usually like 30, 60 days to then give them the search warrant. But it sort of preserves the evidence the moment that you know that you want it, even if maybe you can't get a search warrant to them in time. A non-disclosure order is similar in the respect that if you have, when you have a Facebook account, you have terms of service. And we don't read that terms of service, not even as lawyers. But in those terms of service, one of the things Facebook says is, if the government ever wants to find your information, we're going to let you know that the government is asking for it. And so a non-disclosure order, and it is a court order that's necessary, basically tells Facebook, hey, don't tell the defendant. Violate those terms of service. You have a court order. You cannot tell the defendant. So obviously you can understand why that would be important if you have an ongoing investigation. You can also have a consent to assume an online presence. So this can be helpful in cases where you don't want the victim to shut down their accounts, and actually you want, as law enforcement, to monitor those accounts, or maybe even pretend to be the victim on those accounts. And then you want to make sure that's written consent from the victim. Sometimes we have companies that are not based in the United States, and it's really hard to get information from them. There is a legal way to do it in some cases. I have never had any success on this, and I can't imagine on a stalking case that you would, but good to know that there is at least a process to get information from another country. And then the other thing is, again, this is an emerging legal issue. I find it really interesting, but maybe you don't. And it's this idea of a taint team. And this says you can only search what the search warrant says. So for example, the way it was actually recently in the news, this whole concept, because they executed a search warrant at a law office. And they were only looking for, they said, okay, you have a right to look for document A, document B, and document C. That's all you have a right to go and look for. But in order to look for those documents, they had to go through files upon files upon files. And so what this says is, because we don't want the investigator to see things that they don't have a right to see, the investigator themselves is not the one that's going to go do the search. Instead, it's going to be somebody else that's not involved in the case in any way. All they have is they have the instructions to go find document A, document B, and document C. So that's sort of the non-digital way that this happens. As we sort of digital world has come about, this is an issue with people's cell phones. Because right now, if you wanted to look at somebody's cell phone, you're going to have access really to the entire phone. But if all you have permission to find are maybe a couple of photos and a couple of text messages, then the court might say, you don't have a right to just go look through everything to find those photos. So a way to cure that is to, again, have a taint team, to have unrelated people do that search. And so they just pull out what they're instructed to do. Kind of an emerging issue I see in the tech world coming out. But basically, we just want to make sure we're preserving that evidence however we can. Sometimes it's because we have the resources to do a phone examination. Sometimes we don't. We can still write a search warrant to manually examine a phone. It can be very tedious, but it can be done. And if that's the way that it is going to be done, then you should be video recording the entire examination of that phone. So we had a device where the phone was on the table, and then there was a camera mounted above the phone that you just pressed record, and then it recorded basically my finger going through the phone and going through all the things. Obviously, you can imagine how tedious that is, but just don't take it off the table and think, oh, I don't have Cellbrite, I can't get into this phone, right? So all the different things that you can get off of a cell phone, you guys should, you have your own cell phones, you know what's on there. Another emerging issue is locked cell phones. So obviously, if you're Mark and you're being buddy with the defendant, that's when you ask for consent and ask for those passcodes. Law that's been going out where court orders have been used to order a defendant to give a password. Not super effective because usually they just lie or say they forgot it. But now with biometrics, when we can open our phones with our faces and our thumbprints, you can get court orders for that to be done. But often the ability to open your phone via biometrics stops if the phone hasn't been opened in 4 to 48 hours, depending on the phone. So I'm sure you recognize that when you've had to re-enter your whole password because maybe you just restarted your phone or something. So that's a really time sensitive if that's the way you think you're going to get into the phone. You can also get a search warrant for linked cloud accounts. So if we know the phone's backed up, we can do it that way. And so there's some cases out there. And again, this is something that's going to hit the Supreme Court at some point, basically. So this is a case out of Florida. It was a video voyeurism case, and they compelled the defendant to provide the passcode. And they said, this is not testimonial. This isn't the defendant testifying against themselves. We ask defendants to supply handwriting samples, blood samples. We ask them to stand in lineups. We ask them to do voice exemplars. And this is really just the same thing. And so the court agreed with them on that case. But then another case came out of Florida that said, no, this is incriminating because if it's just not the password itself, but it's the fact that they know the password. That means that they own that phone and that they have control over that phone. And that can have detrimental effects on their case. So stay tuned. And how do we get this all into court? So we usually talk about trying to figure out what are we going to introduce. Usually you have to have something physical to bring to court and have the clerk mark as, exhibit A, and then that's how you admit it. So when we talk about digital evidence, we have to think about what are we physically introducing. Oftentimes a prosecutor will say to me, well, I'm just going to introduce the text messages. How are you doing that? Are you putting in the phone? Do you have screenshots? That kind of thing. So that's the first step. What are you going to introduce? The second step is how are you going to authenticate it? And then the last one is how are you going to link that evidence to the defendant? So when we talk about what are you admitting, it may just be testimony, but often it's going to be maybe records that you received from Twitter or you received from Facebook. It could be a screenshot or a photograph of a phone with the display. It could be a screen recording where you've either videotaped, going through the phone, or now my phone, you can screen record and it'll record your whole thing. It could be a forensic report, which usually looks like an HTML document that's hyperlinked and looks almost like a web page. And that might come on a disk or may come on a thumb drive. And that's what you want to do. Or you could print it out and kill a lot of trees. And then finally, the manual examination. If that was done formally, you'd have a video for that. So that's just like the formal full examination of the phone versus maybe something that the victim did themselves where they just recorded their own screen or they did it with a detective. So authentication is the second step. And that's where a lot of people get stepped up. Judges are not really comfortable with digital evidence. And not all of us are very savvy with digital evidence either. And so this can be a place where there's a real challenge. I remember I had a case with Facebook, messages, and I think the defense did such a good job of confusing the judge and using all these words. At the end of the day, the judge was like, if Mark Zuckerberg is not coming, this evidence is not coming in. So we had to break that down a little bit and do some education. And this is a great way to start. So to prove authentication, really, It just says this is a requirement that before putting something to evidence, the court has to be satisfied that the evidence is what the proponent claims it to be. You need some evidence. This is what I say it is. And really, that's a very, very low bar. The argument later on is not authenticity, but it's usually the weight of the evidence. So the way that you can authenticate something, and your statute goes through many ways, I've highlighted a few. One is testimony of a witness with knowledge. So that is your victim saying, those are my text messages, that's what I received on my phone. That's literally all you need. But sometimes that's not all we need because it's maybe something posted on Twitter. So then you can look at things like appearance, content, substance, internal patterns, or other distinctive characteristics, taken in conjunction with the circumstances. So this is something where you say, listen, this is the pet name he used to call me. This is the coworker who he always says I had an affair with. And this was happening in the context of our split. And so then you just make that argument that that's enough to at least get it over the low bar of authentication. You could also do voice identification, telephone conversations. If it comes from, the ex's phone number and that's known to the victim. Yes, the defense can always claim somebody had his phone, but that's an argument to be made later. This is just getting the evidence in front of the jury. And then foundation, it can just be testimony, but you can also do this with a custodian of business records, or you have something that allows for a business record certification. So this would happen with like Instagram. You want records from Instagram, they're going to give you the records, they're going to send it in a PDF or a thumb drive, and then accompanying that, they're going to send you a certification that says these records were collected in the regular course of action, and then you don't need a live person to do that. And you can also sometimes use chain of custody. So the really difficult part is usually trying to put the defendant behind this evidence, right? He's the one that sent the message. She's the one who made all those phone calls. She's the one that took the photograph. And so the courts have found that you can do this with circumstantial evidence, like where was the device found? That cell phone was found in his back pocket, probably his. Who's the account registered to? The social media account is DV Jennifer. That's probably Jennifer Landheis. Who has access to the photographs? Your victim says, I took these photographs. The only person I ever sent them to was Alan. And are there words or phrases or topics of conversation that are commonly used by the offender? All those things can do that. So this would be just like an example, right? Elliot is charged with stalking after repeatedly tweeting threatening messages to Fran. Search warrant for Elliot and Fran's Twitter accounts. Twitter provides a PDF document containing the requested records. So then you basically say, what are you going to introduce? You're going to introduce that PDF record from Twitter. And you can do that because you've put the records on a thumb drive or a disk, or you can print them out. But you need something physical to come to court with. And this is good advice for any of you that might be working with victims that are trying to get their own protection orders through the civil process. These are exactly how that should be done as well. Obviously, there's usually a little bit more leeway, but it's always good to have like sort of a plan of action. How are you going to authenticate it, right? Is it going to be your victim saying, that's my Twitter account, those are the messages I received, that's his Twitter account, those are the message I received? Or you have the PDF, Twitter probably gave you a business record certification. So that business record certification is going to be the way you authenticate it. And then how are you going to link it to the defendant? And that's usually like, well, the handle is his nickname. Everybody knows him by that nickname. He and I communicated through that during the course of our relationship before we ever broke up. And I know no one else has ever sent me any messages except for him. And that's kind of how you would go through that. So this is just talking about business records. I want to do another one that's kind of similar. This one's on screenshots. Screenshots are admitted just the way a photograph would be, which is, this is the code language. Always good to tell your victim to expect it because it's legal language. Is this a true and accurate representation of your text phone or your cell phone screen, your computer screen when you saw that text message? Yes, the answer is yes. That's all that comes in. The defense can argue to the end of the day whether the judge or jury should believe it, but the fact that it's introduced into evidence is actually quite a low bar. And there may be hearsay analysis if we're talking about communications. This is a case out of California where Instagrams came in and accompanying messages, and they came in both through screenshots and through business records. And what was interesting was that the business records didn't include all of the things that were included in the screenshots. And the court actually said, hey, you know what? There's been enough foundation that we can now infer that some things might have been deleted and were not included in the business records, but they were captured by screenshots before they were deleted, and therefore it all comes in. So good ways to think about it. And I just want to get us to our little last one that says testimony alone is enough. Testimony alone is enough. There you go.
Thank you, Jane. I appreciate, as I always do, I learn something new every time I listen to you talk. And I've heard you a lot and I love it every single time. So thank you for participating today. I don't know if Mark is still on with us, but I want to say a thanks to Mark as well. And all of us have given additional information. The Guam Coalition is putting up information in the chat about how to do your evaluations and how to get the resources. But as we end our time together, like I have said every single day, thank you so much for the work that you all do on an everyday basis. It is our pleasure to do the work that we do and work with all of you. So huge thanks to Jane and huge thanks to Mark, but know that we are not far away. Reach out to us if you need additional help. We are happy to help you. It's one of our favorite parts of the job. So reach out to us if you need anything. And then I will turn it back over to the Guam Coalition if they want to say anything. Otherwise, know that copies of the PowerPoint will be sent to all of you, and PDFs of the documents will be made, and we'll be giving the instructions on how to access all of that soon. So.
Good morning and thank you. This is Taylor from the Coalition. I wanted to reiterate what Jennifer said and thank both Mark and Jane, but as well as Jennifer for all their hard work. We want to send a thanks to the ASL interpreters and our closed captioning folks, as well as Polyron and Dwayne for being back up for this webinar, and also the whole Coalition staff. But most importantly, we want to thank our participants, because without you, we wouldn't have anyone to share this information to. So we thank you for spending your time with us this morning and wanting to know more. We want to do a shout out as well to not only the attendees on Guam, but we also have attendees from Saipan, Palau, Honolulu, and Japan. So thank you so much. And day 4 of our webinar will continue tomorrow morning at 9 a.m. Chamorro Standard Time, and it will be on safety planning. Hope you all have a wonderful afternoon.